So speaking of elections, political ads, I did write in Kyle Fouts' name to be governor. So
It's
you got
going well.
Got one.
So far, so good. I'm not sure where we're at with that, but it's still up in the air.
Still early. It's still early.
That's all
Well, I
right.
don't know. According to some Channel 10, Katie Hobbs already beat Carrie Lake.
I don't know. Elections,
That got
my
posted by
understanding, is
mistake.
tomorrow. So
Yeah, I
we'll
know.
find out.
What's up with that?
All right. Anyways, broker talk with Kyle Fouts. All right, Kyle, appreciate you joining us today. So, I'm going to go ahead and do it. I'm going to reprimand our agents, okay? Because it's one of the things that just, I don't know, pet peeve of mine.
Okay.
When we have you in, or we have our brokers in, Nick's going to get flooded with questions, okay? And we always say, boy, if I had you the following week, we now got a set of questions and topics for you, but you're here this week. Every time you appear on the webinar, you post on our closed Facebook groups, hey, coming on the webinar, and that's why our viewership is down. They know ahead of time. But, what do you want to talk about? And it's like crickets.
It is. Yeah. I mean, we obviously want to bring relevant topics to you. We don't want to just kind of rehash the same issues that we've gone over again and again, although, our role does tend to bring those questions continuously. So we want to make sure we're touching on them for everybody, not just the office meetings that we might be at here and there. We want to get it out to the masses, but we also want to speak on things that are relevant to your world now. So that's why I go into the closed groups and ask for topics to be presented, because I would like to speak to something that's relevant to you, not just me giving you information that maybe you're not too concerned with.
All right, so let's talk about the first one. I may
Sure.
or may not have done this, so I'm curious to know what the answer is.
Okay. May or may not. I like that.
We'll see. We'll see where this conversation goes.
We will.
All right. So a licensee lists her house for sale. Obviously, owner agent. She decides to, and this would be a good place to remind everybody, if you do that, you have to have an owner agent writer.
100%.
Okay. See,
Yep.
I did know that. All right. She decides to hold an open house to try to procure a buyer for the property.
Right.
Question: can a licensee hold an open house to procure a buyer for her own personal property or own house? And then if an unrepresented buyer comes to the open house, can the owner agent represent them? Why or why not?
Right. What part of that did you do?
That's a good question,
Can we
Kyle.
start with that?
No, I have held my own houses open.
Sure. And that part's fine. That to me, that was not the real intent of this question.
Okay,
Not the
my
information I wanted to
intent
get
was
out,
not
but
necessarily to sell my house, because we actually weren't interested in selling the house. I just needed buyers. So
we'll talk about that later. That's
years
maybe
ago,
not-
maybe
okay.
way
Way prior to West USA.
years ago.
Okay.
But I told my wife, hey, let's just put an open house sign out there, meet some buyers, and then take them out shopping.
Nice.
Yeah. So the answer to the second question is, if an unrepresented buyer comes to the house, can the owner agent represent them? The answer is emphatically no.
Emphatically is the right way to state that, Todd. You are correct. And that's
Well, you didn't let me get a chance to finish the answer. I was going to say no.
Gee.
good. Well, nice. I'm glad that you said that, Mike. That's what I was hoping for. And why would that be? Why would they not be able to do that?
Well, I mean, for me, it's there is no way you can convince me that you can provide that buyer fiduciary responsibility that they deserve.
Correct.
There's no way.
Even and so the question we always get is like, I know we have a ton of good agents that are out there that can do an absolutely capable and solid job representing a buyer. But the problem is, it doesn't matter how good of a job you do, if an issue arises down the road, there's going to be problems. You're never going to be able to convince somebody that you represented someone else's interest to the same degree that you would represent your own. It's just it's the way it works.
So then the question is, can you allow them to buy the house unrepresented?
And I have that in my notes. Yep. You can. It's a common misconception amongst agents that if you're the only agent in a transaction, you must be a dual agent. And that's just not the case. You can absolutely be a sole agent on either side. In this case, you're an owner agent selling your own property. So if they want to go unrepresented, they certainly can. If I'm an owner agent, I'm going to encourage them. I'm not giving them any advice, but I'm going to encourage them to seek outside counsel, because I want them to have that representation. But they don't have to. That's their choice. They're adults. They can make the decision, take the risk that comes with it. It's just not going to be me who's guiding them. Okay. We had a situation come up recently. An agent asked me, okay, but this agent this buyer who's unrepresented wants me to write the contract for them, send it to them e-sign to be electronically signed. Can I do that?
Legally.
The answer is can you do that? Yes. But here's how I would handle it. I mean, ultimately, first I would send them a blank contract, okay? Because I want them to read through it. Then, if I did send them a contract that I had filled out, I would send it to them as a PDF first. I would not send it to them as to be able to be electronically signed, because we all know people click, click,
Yep.
and they're done. It leaves open the argument that, hey, you slipped something in here that I wasn't prepared for, that I didn't notice, and now you the professional has taken advantage of me, the poor consumer. And that's clearly not what we're doing here. You've asked me to write the contract. I'm doing that. So when I send that as a PDF, I'm telling you, please read through this very, very carefully. These are the points that you wanted me to include in this contract. Please take it to an attorney. Please take it to a trusted source. Whoever you see fit to vet this contract, please do that. And once you've done that, then I can send it to you as a DocuSign, an e-sign,
Are there
AuthentiSign,
any
et cetera.
disclosures that you need to make on page 8? Anything you need
Just
to write in there?
other than the fact that the owner is a licensed agent in the state of Arizona, no. That is the important one to get out of there when owner agents are.
All right, and a good point. Nick reminded us. We do have quite a few agents on our Monday morning webinar that aren't with West USA. You should be. So this would be the time to say you need to confer with your own broker.
Thank
on this.
you. Yes, that absolutely. Don't take my advice. Take your own broker. It's not going to say like, listen, I heard Kyle say this. They're not going to care. Although I'm right.
All right. So I actually had this happen.
Okay.
So
unfortunately.
Yep. So an owner of a property commits suicide in the home. The personal representative of the owner's estate did not disclose this in the SPUDs. So did not disclose that there was a suicide in the home. After the inspection period had expired, the buyers learned from the neighbor that the seller had committed suicide in the home. Can the buyer cancel the contract? My situation was a little different, but I actually was the buyer. But I would say my understanding is that a death, regardless of how the death occurred, unless the house was haunted and it was a ghost, that it is not something that needs to be disclosed. Therefore, I would say that the buyer cannot cancel the contract because of this.
So it doesn't. 322156 Arizona Revised Statute says that there are three things that a real estate agent and the seller cannot be found litigiously liable for not disclosing. One is sex offender site, sex offenders in the neighborhood. Two is if someone that possesses the home had AIDS or HIV, and the third one is that there was a horrific crime, whether it was a homicide, a suicide, or some kind of felony that was committed in or on the property, then the listing agent and the seller would not be found litigiously liable. But the question is, can the buyer cancel a contract? And the situation would be not for that particular purpose. They can cancel a contract. It's outside the inspection period, so they don't have those same rights that they would have had if they hadn't yet submitted the BINSR. So from that particular perspective, they can always cancel, but they should go to an attorney and find out what their liability is.
That is 100% the answer. Yeah, that's to me the reason I brought this up. The answer, the stigmatized property laws. Most agents are aware of that and know that issue does not need to be disclosed unless you're directly asked. If you're directly asked a question, has somebody died in the property, you can't overtly lie. And you can't say, I don't know if you do. You can say, legally, I'm not obligated to answer that, which if you answer that way, you know what the answer is, right? We know, and that's okay. But that's your right. You don't have to overtly disclose it. Why I wanted to bring this up is because there are a lot of things contained in the due diligence section of the purchase contract, section 6, that are bolded, that ask for the buyer to investigate if it's material to them. Things like square footage and flood hazard insurance, sewer connection. This is also one of those things. If someone passes away in the property you're about to purchase, is that material to you? It may or it may not be. But as agents, we need to make sure that our clients are fully aware of what we need to be looking at during this due diligence section. Because when does the square footage often come up? During the appraisal,
yeah.
Right? So if I'm buying a house that's said to be 2,400 square feet, appraiser does the appraisal and it comes back at 2,000, but it comes in at value. My buyer says, wait a minute, I'm paying X for a 2,400 square foot house. I don't want to pay that for a 2,000 square foot house, right? That's something they should have investigated during the due diligence period. It just, a lot of things get kind of skimmed over when it comes to, yeah, you'll have your home inspection. Yes, you'll have your termite inspection, but these things are not necessarily specifically pointed out. And so when they become an issue and the agent points out this section of the contract, the client is, often has the argument of, well, wait a minute, I didn't know that. You were supposed to advise me of that, right?
Yeah, and giving them also a copy of the buyer advisory document, which is
100%.
great because it's got every single website and link and everything else. But more importantly than anything, the SPDS and the buyer advisory teach people things that they possibly didn't know they could investigate. And that's another issue, is the fact that, the consumer may have found a particular item offensive or as a material fact of now they want to pay less or not buy the house.
Right. Yeah. It's just make sure, I guess the point of the question was just to bring up the fact, make sure that obviously we're all going through the contracts with our clients, but be very diligent in those sections to say, we need to look at this. We need to look at that, just to make sure that it's clear in their mind, the things that they should be looking at. Make sure you document that as you do all things email wise, just to make sure that you have proof when they say you didn't tell me.
All right. Number 3, obviously, and this is one of the things that I wanted to have a discussion with you about, but there's been a distinct shift in the market dynamic over the last several months. And, and what are the differences in conversations that we are encountering with our clients? What types of things are we seeing that were non-existent in last year's market, and what do we need to be careful of? And the reason that I brought this up, because last year, when it was a seller's market, the conversations that we were having with buyers, and I talked to my attorney I had breakfast with him about 2 months ago, and I go, are you seeing activity with buyers coming to you and saying, hey, my buyer's agent didn't really explain things. I kind of felt pressured into buying something above list price, waiving appraisal, waiving inspections, and so forth. So I don't want to harbor on that. We're in a different market. So are we saying things to our sellers that potentially could get ourselves into trouble?
Well, and that's where we as agents have to be very careful with how we frame our conversations with our clients. It's never about what they must do and what they have to do. It's always, here are your options. Here are the things that we have seen be successful for other people. Here are things that other people are potentially doing that might make their property more desirable to the consumers that are out there when we're competing with, as Todd said, 20,000 plus listings versus 8 last year. I mean, it's a very different market, and those conversations need to be had with our clients, making sure they understand what they can do to make their property maybe a little more desirable versus what they must do or should do. It's just, those are the kind of conversations when you talk about buyers, agents now maybe being a little bit in the hot seat. It's because agents were telling or could be telling their clients that, you have to pay above list, you have to waive the appraisal, you have to waive the inspection. Otherwise, you're just not going to win the bidding process, which it may have been accurate in some respects, but it's not. You have to. The buyers and clients, I guess I shouldn't just say buyers, but clients always have an option. They're just simply options for people to either take or not take.
Remember, and I think Todd, for me, it's how do we present price to a seller in this market, as opposed to I know that if we want a shot at selling your home, we've got to be at this price. But I can get myself into some trouble in how I present that.
Well, that's where the statistics that we do every Monday have really fall into your lap. We do the list price to sell price retention, which basically tells you what the average seller in the MLS is discounting or accepting within the offer. There are clues, and we try to explain how the statistics, how it affects your business and what you need to do to overcome that. Mike, we talk about what took place over the last 3 years, which we're not going to digress to. However, realtors are the part of the job is to share what I call historical perspective. You're not supposed to speculate on where the future is going. You're not supposed to speculate on what the house will be worth based on even a common 4% appreciation, which we all know. You're not supposed to talk about future value because you cannot guarantee the market is going to do that. And just to Kyle's point, when we were, and Michael, to your point, when we were telling people they had to pay more than comparable value, not fair market value, because fair market value is what the willing buyer and a willing seller come together on, but comparable value. When you start doing so I'd say the answer today to initiate the conversation is to say, Mr. and Mrs. Smith, here are the comparables. The comparables, show the last 6 months of any activity that's taken place within the neighborhood. We do and explain what you're putting into the computer, 10% high and low square footage, the same year, similar like properties, and what your objective is. And then when you get that number, Mr. and Mrs. Smith, here's what the market says your price, your property should be listed for. You can use the statistics to validate your position, but the moment you speculate, that's where liability comes in.
Kyle, can I go to a seller and say, okay, to Todd's point, I'm not an economist, but based on my numbers, based on my experience, and based on my research, if I was the owner of your home,
sure,
and I was going to put that house on the market, this is what I would list it for.
That's, as agents, we're going to have that conversation day in and day out, and that's okay. That the way you frame that was fine. There's nothing wrong with it. It's just when you give it more as a directive to a client that this is what you must do, or this is what you have to do to sell your house. That's not maybe not accurate. It could be, it comes from the same place, but just the way that you approach that conversation can make a big difference in the mind of a client.
Just remember, whenever you present something, you have to not only present the positive, you have to present the negative as well. So the consumer's context is, okay, this could happen and I could benefit, or this could happen and I could lose.
Right. We're not,
It's not just one side of that equation, even if it is something we would do.
Well, and that's the market conditions advisory. That's why it's a big get out of jail free ticket.
All right. Yeah. And then the other thing I would tell them, if it was my house and I was bringing an agent over, I would have a bottle of Maker's Mark and a steak on the grill.
Right. You have that conversation before you get there. Yes.
All right. So Tales from the Courtroom. Going to be honest.
Don't know.
No idea what we're talking about.
Yep, that's okay. And I figured that would be the case. It's just, this is something, if you go to the AAR online website, okay, the Arizona Association's website, and you type in the little search Tales from the Courtroom, there's a few articles written by Michelle Lind, who's the past CEO. She's an attorney. She's fantastic. But this one brought up a conversation that I thought was worth having a chat about. So essentially what happened is this agent was part of a buying or representing a buyer purchasing a hillside lot in an exclusive part of town. Obviously, there was some back and forth about a road. There was no access at the point that they purchased it. Anyway, that transaction closes. Those buyers turn into sellers, go to list the property. And the new buyers that are coming in have conversations with this particular agent who helped on the purchase side of it and is now the listing agent, wanting to know about the access and the road that's going to be built or that is being built. And at all points, these buyers, it sounded like, given the article, and you can read it at that on the website, but they went back to this point several times over the course of the escrow, asking about the road. And the agent was taking the information that he learned from the purchase, and he was specific. He was giving that information to the buyers in this situation, but not telling them, essentially, you need to go research this on your own. He wasn't their representative. He was not a dual agent. They had their own representation, but they were always pushing this road issue with him. I mean, long story short, you can see where it's going. He says, yes, the road's fine. The road's fully permitted. We have all the things that we need. The road's not going to be an issue. They purchase the lot. They close escrow. They go to build their dream home side of the mountain, and now they can't get the road permitted. Okay. That's a big issue for agent number one, right? And so what I wanted to get out of this is essentially clients and even customers in this case, people look to us as agents because we're the ones that are in front of them. They want you to be all things at all times. You're the one they're communicating with on a daily basis. We have to be careful with how we answer that. The natural inclination is to want to help, to want to give the information they're seeking, right? We all want to do that. But that gets us into a position of liability very quickly. right? It's a you're making estimated or you know you're giving information that you're being given, so you feel that as though it's accurate, but now you're taking ownership of that information by giving it to someone else. And what do we learn when we're in real estate school? It's one of the first things they teach you. Be the source of the source. You don't want to be the source of the information personally. You want to make sure that you're pushing them to a place that is the source for this information. That takes the liability off of your shoulders, and it also keeps you from guessing, right? You just don't want to be in that position, and it's an easy place to get to.
It's like using another agent's school codes or using another agent's last tax.
Why are you looking at me when you said that?
Well, no, I'm just saying.
I may or may not have done that before.
Sewer septic issues, again, the last seller said it was on sewer, but afterwards they find out it's really on septic. But you were the listing agent. You didn't investigate it. You didn't tell your seller to investigate it. You just used the previous agent's listing. These are all things that just obviously are going to come back to haunt us. And and moving forward on this particular topic, to your point, is you need to investigate this for yourselves.
Correct. Yeah. Just or if people are asking you the questions and you don't know, you have to be okay saying, listen, I don't know. Like that's an okay response to a client or a customer's question. We're not going to, you don't know everything, right? Surprisingly.
Yeah. Shocker.
I know that's hard for you to hear, Mike, but it's the truth.
All right. Number 5, are single agent, dual agency, and dual agency with 2 agents the same? Are they handled differently? Ooh. Well, the answer to the first question is, well, of course they're not the same. You're talking about 1 person versus 2 persons. So that's my easy answer.
That's wow.
Wow. Okay.
Hadn't thought of that answer.
Yeah, gee, that's whether you fill out both lines on that form or only one.
No, so I would say no. A single agent, dual agency is first of all, it comes down to the broker.
Correct.
Right? Who is the broker, and are both parties underneath the governance, which is not really quite the right term, but under the same brokerage and the same broker. So as a single agent doing dual agency, not only is Dwayne the designated broker in this, but I am now representing and trying to provide fiduciary responsibility to both parties. As far as dual agency with 2 agents, buyer has their own agent, seller has their own agent, but we have the same designated broker.
I am so glad you said that last comment. This is a thing that I think most real estate agents don't know. First of all, we all hear that the broker owns the listing. So the broker is the entity. Then the entity hires a designated broker that they designate to be the supervisor, and then that person has licensees and blah, blah, blah. They give you limited authority to enter into real estate transactions. So, okay, you're out there, you're a single agent, but who owns the listing? The broker does. So in actuality, I hear agents say this mistake all the time at an open house. Oh, I'm not the listing agent. As you can see on the sign, that's Mike Weinstein. I'm Todd Menard. I'd be your buyer's agent, and he would be representing the seller. That is not true. Both agents now represent both parties because the designated broker now represents both parties.
Correct. And that's what I wanted to get out of this essentially is they feel different because, being a single agent, dual agent, you're walking and towing that line, right? You're in the middle of it. You're just passing information back and forth. But it is in a limited capacity, which is why the document out there, consent to limited representation, exists, right? That's why you have them sign it prior to entering into the contract. But with 2 agents, that feels very much like a standard transaction. That feels like me with any other brokerage. I'm representing my client. That person over there, who I may or may not have met, is representing their client, and we're just going to kind of go to battle like we always do, right? It's trying to further the interests of our client. Excuse me. But at the end of the day, when it is when I say, are they handled differently? They're not, and they can't be. Okay. And people, especially with a brokerage of our size that has 3,100 plus agents, we have to be conscious of the fact that there are going to be a lot of situations that arise where this comes to pass, where it is a listing of ours with a West USA agent and a buyer represented by a West USA agent comes in, regardless of kind of how that happens. Once it happens and you're in escrow, you have to treat it the same as if you were the single agent walking the middle line between the 2 parties. Okay. One agent cannot advise their side of the transaction to the detriment of the other side. And if you think about it, a lot of things that you would advise could potentially be viewed through the lens of being detrimental to the other side,
like
right?
comps.
And well, just a lot of things. I mean, you're trying to further your client's position, but you have to be very conscious of, we're in a dual agent situation here. I need to be very careful, again, how I frame my conversations and the type of advice. It's always giving options. This is here's what you can do, not what I think you should do, because now I'm advising you, which could be to the detriment
All
of
right,
them.
so not to put you on the spot here, but I will.
Please.
Give me an example of where under a dual agency scenario, where I might be advising my client to the detriment of the other party. Or Todd, feel free to jump in, because Kyle's got that
deer in headlights.
Yeah.
I like specific questions, Mike. Open-ended things are not
So
my forte.
fine. So then pick on my example
Okay.
after I'm done. One of the biggest things that it is that a buyer. Well, first of all, every agent at West USA is a listing agent for any listing West USA has. So when you're holding an open house thinking you're surfing for buyers, and you're not the person who signed the listing agreement with the seller, please understand your broker did, because the broker owns that listing. So it puts additional burdens upon that person. Like, for instance, you're there finding buyers, but that does not exonerate you from having to try to sell the house, knowing the feature benefits about the house, asking for the order, things of that nature. Only when the consumer says, yeah, there's nothing you could do that would make me want to buy this house. So maybe at that point you'll step over that imaginary line in the sand and start working with the buyer. Well, come over here on my computer. I've got properties like this that I can take you to go see. Then all of a sudden the consumer comes to the realization, I really like that property. So now you got to go back to that original property, and they want you to pull comps. My understanding from years ago was that you can't pull comps if the comps don't justify the value of the listing. And so if you share comps with the buyer that say that the listing is overpriced, we now have potentially a fiduciary obligation issue with the seller.
Yeah, that's and that's something you would really never think of, right? Like, you're like, this is what I do day in and day out with my buyers. I'm going to pull comps. I want to show the value, or show them what the prospective value is. And now it could be seen as detrimental to a seller. I haven't seen, not that that occurs day in and day out. Right. I haven't seen that be an issue, but it absolutely can. Like, you have to think about it in like from a seller's perspective in that specific instance. Could they frame it in a way that was detrimental to them? Because that's, at the end of the day, who's going to be the complainants in that potential lawsuit? Well, in that case, it would be the seller. You advise them to offer me a lesser price. That stuff, I mean, that's what you have to be careful of. Mike, to your point, I was trying to think of an example while Todd was talking. Maybe like an earnest money dispute down the road, where a buyer does something potentially that they might not, or maybe shouldn't have done, and now they're walking through that dispute path. And now
let me give you an example, because we've got a minute. So I did this, but the listing agent, it was with a different brokerage. Mm-hmm. Listing agent, very clearly, they wanted earnest money to go hard, VA loan, and wanted to write it, us to write in as is language. I told my client, listen, we can write in as is language all day long. It's not enforceable. We still have the right to do our inspection period. And still make requests. So let's just take advantage of the listing agent's ignorance, because she got her license not too long ago. Would that be an example?
If they were both the same broker.
Correct.
If they were the same broker.
There's other things to unpack in that specific scenario that
we'll talk later.
Give us. Yeah.
Well, I know we're out of time, but here's the thing that I just like to make sure everybody understands. When we say to a customer, sign the real estate agency disclosure and election form, and we ask them to check that third, or we pre-check that third box that said, you're allowing me to show you properties listed with my firm, you better make sure they understand that if they decide they want to purchase that property, what the takeaway is as far as representation for them. Because here's what most people say: I'll represent you and your specifically, and the listing agent will represent the seller specifically, but that doesn't work in a dual agency scenario.
Absolutely right, Todd.
Kyle.
Thanks for having me.
You did last time subpar performance, today above
all the other brokers at West USA are on here, so we're going to pull them after.
I'm sure.
Appreciate it as always, and I want to thank the entire team for a great podcast this morning. And we leave you. Oh, I didn't even read the quote of the day. Gosh, darn it.
Back.
Yep.
There we go. When you achieve one dream, dream another. All right, now we get to the end. Appreciate everybody joining us. Go out and sell a home.
Go Notre Dame. Maybe